Okay, this is file 20-20156-FH, People versus Emily Ann Dietrich. We are here today for a hearing on a alleged violation of probation for failing to pay child support. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Pappen?
Apologize, Your Honor. Craig Pappen appearing on behalf of the state.
Rhonda Underwood appearing on behalf of Ms. Dietrich this morning, Your Honor.
All right, and where do we stand, Ms. Underwood, with Ms. Dietrich's case?
Ms. Dietrich has an appointment coming up with the disability doctor, Your Honor. And also she's working with Michigan Rehabilitative Services to see about things that could be done to get her back in the workforce. I would ask for perhaps a maybe 45-day adjournment to see if we can get those results of both those things.
Is that agreeable with the state, Mr. Pappen?
Your Honor, I understand it was back in October, I believe it was October 28th, 2024, we had, or 2023, we had an adjournment for the same purpose. My concern is that while this is only an arrearage only case, current balance arreared is $29,333. It has been a little over just about 4 months since the last payment. Even in 2023, the payments were spotty, and at least a couple of months there were no payments at all. So we're concerned about that as well, adjourning again for the purpose of the disability determination when this had occurred back in October as well.
Do you have a more recent payment? I have a last payment of October of 2023.
I apologize. You're correct. That's correct.
Okay.
So it's been well over a year and 4 months.
I think at this point, it probably makes more sense just to set it for hearing, and she can present her evidence as to disability, and I can make a decision on whether or not that constitutes good cause. But I don't think adjourning this out any further is going to be useful.
Thank you, Your Honor.
Ms. Clark, can you find us? We'll probably need a 1 hour block time for a violation of probation.
February 27th at 3 o'clock.
I'm sorry, did you say 3 o'clock?
Yes. Yes.
That would work for Mr. Pappen and Ms. Underwood.
Yes, Your Honor.
What is that time on February 27th, Your Honor?
3 o'clock.
And what day of the week is that?
Friday.
That's a Thursday.
Oh,
Do we have anything a little earlier, maybe?
We could do 10 o'clock on the 27th.
That's fine.
Okay, so we'll set it for February 27th at 10 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Dietrich, you can go ahead and log out. Ms. Dumont, are you ready to proceed with Ms. Rule?
Yes, Your Honor.
Okay, and just 1 second. What's this? Okay, Ms. Rule, you can come forward and sit at the table closer to the jury. So I say downstairs. This is file 24-51568-PH. Christine Ann Rule versus Karen Marie Rule. We are here today for a hearing on an alleged personal protection order violation. We are proceeding today partially in person and partially by video conference. Ma'am, you are Christine Ann Rule, correct?
Yes, sir.
Okay, Ms. Dumont, do you want to place your appearance on the record?
Katerina Dumont for Karen Rule, the respondent.
I can't hear anything.
Yeah. I think I just heard Ms. Rule say she can't hear anything. Karen Rule, are you there? Can you hear me?
Your Honor, I've spoken with her, so she knows how we're going to proceed today. If she's new at Zoom.
Okay, well,
Can't hear
how is
anything,
it
Katerina.
proceed today?
Your Honor, Miss Christine Rule did provide me with the screenshots that were referenced in the attached police report with the show cause. At this point, we would like to set a hearing with regards to the alleged violation.
All right, Ms. Clark, we have a 1 hour hearing for the PPO violation.
Yes, February 28th at 1:30.
Your Honor, I have a evidentiary hearing at the same time in front of Judge Anzalone. I apologize.
Or Tuesday, March 4th at 11 a.m.
That works.
Ms. Rule, are you available at that time?
Yes.
So March 4th at 11 a.m. Okay. Court will send out a scheduling order with that date in it.
Thank you.
And Ms. Dumont, I trust you'll contact Ms. Rule and let her know what happened.
Yep, I'll contact her right now. Thank you.
Okay. Okay, let's see, Ms. Underwood, I have Mr. Cranker is here by Zoom. Do you need to speak with him?
I believe that is a show cause, Your Honor. I don't believe I've been appointed on that one.
Okay, all right.
Morgan's County Judge Chambers. We have Judge, please. Yes.
Okay, Mr. Cranker, can you hear me?
Yes,
All right. So this is file 23-21391-FH, People versus Zachary Richard Cranker. We are here today for arraignment on a bench warrant for alleged failure to appear at a court hearing. We are proceeding today by video conference. And sir, you are Zachary Richard Cranker?
yes, sir, I am.
Okay. Mr. Cranker, have you received a copy of the warrant?
No, I have not.
Right. We will make sure that we get that to you. I will let you know that the warrant alleges that you failed to appear for a show cause hearing on an alleged violation of probation back on May 15, 2024. The underlying summons for the probation violation alleged that you failed to report to the Lenawee County Jail as ordered by the court to serve your jail time that was a part of your probation sentence. The maximum possible penalty for the failure to appear at the show cause hearing, failure to appear in court, is up to 93 days in jail or $7,500 in fines. The probation violation, underlying probation violation, you had pled guilty to attempted breaking and entering a building with intent, and the maximum possible penalty for that offense is up to 10 years in prison. Do you understand all of that?
Yes, sir.
You do have the right to be represented by an attorney at this hearing and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney?
Yes, sir.
Obviously, you don't have the ability to pay for your own attorney because you're incarcerated. So I will have you speak to Ms. Underwood from our public defender's office. Ms. Underwood, do you need us to send you these documents?
I have the documents, Your Honor.
Okay.
I should say I have the request and warrant for the probation violation. And I'll check for the.
Okay, I have jail room 4 logged into the Zoom session. The camera is off and the microphone is muted. There's someone in that pod. I just sent a request to turn the camera on. Yes, please. Let's see, Mr. Amadeo, are you ready to proceed with Ms. Frank? I am, Your Honor. Okay. Right, this is file 23-21418-FH, People versus Carly Lynn Frank. We are here today for a pretrial conference in this case, and we are proceeding today in person, partially by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Ellison Arnold for the people.
Good morning, Your Honor. William Amadeo, P7619, for behalf of Carly Frank, who's my left. Carly, please state your name for the court.
Carly Frank.
Okay, and Mr. Amadeo, where do we stand with Ms. Frank's case today?
Judge, I have reached out to Ms. Frank several times. She did not get back to me, but she did email me this morning. I personally feel, Your Honor, that she may need another competency. I have not been able to meet with her. I have called, but she explained a few things to me, which I don't want to break confidence on in the email today. I don't know where the people stand. There's cases struggle on a while. I believe I'm the third lawyer, but I do think there's some motions I need to write, but I do need her assistance. I don't think her mental health is quite there to assist me. I know she had a competency before. I don't want to ask to withdraw, but I'm having a hard time helping her. But based on what was explained to me this morning, I don't know if that's intentional, Judge. So I'll lay to the discretion of the court. I did review all the evidence. I do feel there's some motions that could potentially be beneficial to her. I need to interview her mother who's homeless, and Carly explained a few things to me today with her mental health that may be leading to this situation. I don't think it's intentional with Ms. Frank, but you can't be diligent, Your Honor, if I can't speak to her, and that's the issue I'm having right now.
Ms. Arnold, anything from people's side?
No, we would just defer to the court unless.
All right. I guess the difficulty I'm having is that the report from the Forensic Center is dated October 8th, 2024, based on an interview that occurred October 3rd. So there hasn't been a lot of intervening time here. I understand that time isn't necessarily an indicator of what happens with respect to mental health.
Judge, I think I was on this case in December because Ms. Hannigan left. I do think I was put on there because it was a conflict. Mr. Casper asked me to jump in. I don't know what happened before my time on this case, Your Honor, as far as what the interviews were, but I do feel based on some of the emails I received, because generally I get an email or a text the morning of our pre-trial, and a few things were explained to me today. I don't know where her mental health is. If you want to set it for trial, I will certainly be as diligent as possible, and I'll write up some motions. I do think there's some motions that would be beneficial to Ms. Frank. But my issue, Judge, is I need to communicate with my client. If this does go to trial, I think I may need to put her on the stand based on the facts presented. And if I can't prep with her, she's going to be in a deficit. I know it's not your problem, Judge, but to be as diligent as I can for her, I really do need to prepare with her. And I'm making the efforts. And I don't think she's intentionally blowing me off, but there's no communication from her.
I'm sorry.
No, go ahead. I was explaining something. Go ahead, Judge, I'm sorry.
Am I understanding you correctly to say that you believe that that lack of communication is a result of a mental health issue, not a result of just?
From what was explained to me today, Judge, I don't think it's intentional. She's just disrespecting the process. I do think there's some mental health issues that have been explained to me, and I've tried to reach out to her mom as well, because that's one of the numbers I had. I think her mom's phone is not working because the number I had is going right to voicemail or it's being disconnected. I'm not getting through, but I do understand. Correct me if I'm wrong, Ms. Frank. Your mom is homeless now?
Yeah, and where you staying.
Okay. And when I initially took over the case, your mom was not homeless, correct? But she is homeless now.
Yeah, this one.
Okay. So, Judge, a key witness appears to be homeless, not being able to communicate, and Ms. Frank does have some mental health issues. If we're forced to set this for trial, I will certainly do my best, and I can prepare the evidence, but I do feel I need to be diligent with both those witnesses, considering what I've reviewed. To be quite frank, there's a potential fruit of the poisonous tree argument I think I could make. From the videos I saw, I don't think the consent was given voluntarily, but I need to talk to Miss Lightfoot to really analyze that at my office or on Zoom. I could even come to her. But she's homeless. Is she in a shelter or anything? Where is she at? You've been living in the car? Okay. So that's my dilemma, Your Honor.
Okay, so I'm still trying to get to the heart of, I mean, you said you've requested a second competency review.
Based on
And
what was
what
explained.
you're talking about now is inability to contact another witness.
There's two things. I think Ms. Frank needs a competency based on what she explained to me. And Ms. Lightfoot, who would be a key witness to this case, I need to interview, is homeless. So there's two issues I'm dealing with, Judge. The case stems from an interview with Ms. Lightfoot, who is Ms. Frank's mom. And I do believe there was consent given invalidly. I need to talk to Ms. Lightfoot about that. As far as Carly, who's the actual defendant, who may need to take the stand if I proceed to trial, I would need to prep her, and I don't think her mental health's there. So I'm dealing with two issues, Judge.
All right, so based on Mr. Amadeo's request, I will refer this to the Center for Forensic Psychiatry for a competency review. And based on the last one that was performed, that looks like we should set this out for about 3 months.
I will prepare an order later today, Judge. I gotta go to Flip, and I'll get an order over to your staff if that's acceptable.
That is fine. So let's set this for May 21st at 8:15 a.m. And so Ms. Frank's going to be responsible for appearing at the Center for Forensic Psychiatry when that interview is scheduled. So and there's some difficult issues, but that's something that's going to be defense's responsibility.
Your Honor, just for the record, and I do need Ms. Frank to contact me, but if she does reach out to me, I will make sure she gets there. You're not gonna pay for an Uber. I don't want her to miss it. You do understand you'd be held in contempt of court if you miss this, right? He can lock you up. You understand that? Okay, Judge, that's all I want to make the record.
All right, is there anything else we need to address with this case today then?
Not for me, Your Honor.
No, thank you, Your Honor.
Okay, thank you. And I apologize, Ms. Underwood, I interrupted your breakout session with Mr. Frank. You need to go back to that breakout room. Ms. Underwood, do you need to go back to the breakout room with Mr. Cranker? I inadvertently closed that.
Just briefly, Your Honor.
Okay, 1 second. You want me to? Okay, Mr. Sala, Mr. Bishop is here. Do you need a breakout session with him?
No, I don't believe so, Your Honor. Actually, yeah, why don't you, if you would, please give me a short breakout room with him.
And Mr. Dagger Margosian, Ms. Edwards is here in the courtroom. Are you going to need to speak to her?
If I could, Your Honor, please.
Okay, Ms. Edwards, if you'll step outside to the hallway, there's an iPad out there that you'll be able to join a breakout session with Mr. Dagger. Sergio, if you help her get the camera turned on, with the microphone on. Oh, maybe he has it. Ms. Edwards, need to unmute the microphones. If you tap the screen, there should be a microphone. There you go. All right.
She didn't do, she.
Ms. Eaton Gordon, are you ready to proceed with Ms. Gessman's case?
Yes, Your Honor.
This is file 24-21976-FH People versus Gianna Isabel Gessman. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Nancy Eaton Gordon appearing as a special assigned counsel for Ms. Gessman.
And I am aware that after Ms. Gessman was released from the jail on the PR bond that I issued last week, she had another warrant and was taken to Monroe. And Ms. Eaton Gordon, I think you have some further information about what happened from there.
Yes, Your Honor. It unfortunately was a series of unfortunate events. Ms. Gessman was released from the jail that same day, albeit late, about 4:20 in the afternoon. The jail was aware and had contacted Monroe County about a warrant that was in the system. They had indicated at that time they did not want to pick her up. However, after she was released sometime that evening, and I don't know the circumstances of it, but she made contact with law enforcement here in Lenawee. They again contacted Monroe because they were aware of the warrant. And at that point, Monroe County agreed to meet Lenawee County halfway and have her picked up. She was there on an old matter and was released on a PR bond, I believe, the next day, with set up to go to the shelter nearby. On the way to the shelter, her mental health issues became very clear, and she was picked up and taken to Monroe Hospital, where she was held, and to my knowledge, as of about 6:30, 7 o'clock last night, is still held. The plan is, I'm speaking through Todd Wright through our CMH, because I can't get direct information without a release from the hospital. But my understanding is that they're attempting to coordinate between the hospital and our CMH, that when Ms. Gessman is released, potentially as early as today, she's going to be on some different medications, and they are trying to get her back here so she could get reestablished with our CMH, continue services, and then get to the shelter, share the warmth, which is what we had originally planned with the court. I am still looking for updates. I was just checking my phone to see if there was a new email from Mr. Wright, but he has been in contact with myself, with Darren Coast, and I have been in contact with Phoebe McClure, prosecutor on this file. I understand Ms. Arnold's filling in for her. But I don't think it was intentional that my client is not here. I think she just was picked up and taken to a different location where she can't physically be here and is now in treatment. So we would ask for the court to set this out to allow things to play out, and hopefully for our CMH to again get hands on her to where we can get her into services and continue as we had planned. The issue right now, and if Mr. Coast has any other information, I do want him to correct me, but the information I'm being told from CMH is because she doesn't have current services, they can't just go there and pick her up. So it's a little bit of a back and forth of how we get her when she's been transported out of our county over there and she doesn't have established services where we can just go get her through our CMH. So they are trying to work on a solution right now to get her. I kind of half-heartedly had suggested that if law enforcement needed to be helpful again, maybe they would help in getting her back here since they helped get her there, but I'm not sure if that's a viable solution. So I think we just have to let Mr. Wright and the hospital coordinate what they can to get her back in Ludwig County, and then he and Mr. Wright and his team have vowed to get her on services as long as they can get her here and get her reestablished.
Okay. Anything from the people's side, Ms. Arnold?
No, thank you.
Okay. Obviously, it's a difficult situation. I guess, why don't we adjourn this to March 5th? Yeah. Hopefully by that time, she will have been able to get back here and hooked up with our CMH services here in Miami County.
And I will continue to provide updates to the prosecutor and also to Mr. Coast as I receive them. I would ask if they do get any updates, they provide the same, and I know they will. Would that be at 8:15 again, Your Honor?
Correct.
Okay. Thank you. I have nothing further unless the people have anything.
No, thank you.
Okay, thank you.
Thank you.
Okay,
Your Honor, can I approach for just a second? Sure. I see Rhonda has Cranker this morning. Yeah. I'd had Cranker too, but the issue is I have to withdraw from all cases that are conflict cases.
okay,
So I'm getting a list together of those. There's a lot.
okay. I've only got him on the one violation of probation.
Okay.
If you've got other ones.
Yeah.
Draw just.
I'll do that. Thank you, Judge.
Thank you. Okay, Ms. Underwood, are you ready to proceed with Mr. Kranker?
I am, Your Honor. Thank you.
All right, back record in file 3-21391-FH, People versus Zachary Richard Kranker. Ms. Underwood, place your appearance on the record.
Rhonda Underwood for Mr. Kranker this morning, Your Honor.
And do you know how Mr. Kranker would like to proceed?
Mr. Kranker wishes to accept responsibility and plead guilty to the violation and the bench warrant, Your Honor.
Okay, Mr. Kranker, would you raise your hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Zachary Richard Kranker, correct?
Yes.
Mr. Kranker, do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout that trial you'll be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
Do you also understand that you have a right to contest the contempt of court charge for the failure to appear at court?
Yes.
You understand that throughout that trial you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
In either or both trials, you'd have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yeah.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you have the right to testify at trial if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you violated the terms of your probation by failing to report to the Lenawee County Jail to serve your jail sentence?
Guilty.
And how do you plead to the charge that you committed contempt of court by failing to appear at the summons for that violation hearing on May 15, 2024?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
So you were sentenced in this case based on probation back in April of 2024. Is that correct?
Yes.
And one of the conditions of your probation was that you serve some jail time. Is that correct?
Yes.
And the court gave you a report date to come to the Lenawee County Jail, turn yourself in to start serving that sentence. Is that right?
Yeah.
And that was April 26, 2024 by 5 p.m. Would you agree with that?
Yes.
And you did not present yourself to the jail to start serving that sentence by that deadline. Is that right?
Right.
As a result of that, the court issued a request and summons for probation. I'm sorry, issued a request and summons for probation violation, which directed you to at court on May 15, 2024. Is that right?
Yeah.
And you did not appear at that court hearing. Is that correct?
No, sir.
No, you didn't appear. No, that's not correct.
No, I didn't appear.
Okay. I will accept the pleas that they've been given understandably, voluntarily, and accurately. Mr. Cranker has had full knowledge of his rights and he has had competent counsel. I will refer the probation violation issue back to the probation department for an update of your pre-sentence investigation, and we will set sentencing for, let's go with February 21st at 8:15 a.m.
Thank you, Your Honor.
Can I have a breakout room with him, Judge? And Rhonda, if you'd
Yes.
like.
Ms. Underwood, do you want to be a part of that breakout session?
Your Honor.
Okay, give me just one moment to close out all the old ones and restart that.
Who's she?
Huh?
Who's the Jennifer Walsh one in the room?
Probation lady.
Okay, Mr. Sala, are you ready to proceed with Mr. Bishop?
Yes, Your Honor.
This is file 23-21238-FC, People versus Nicholas Joseph Bishop. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Stan Sal on behalf of the defendant, Nicholas Bishop.
Okay, and so we recently adjourned the trial date in this case. It's my understanding there are still some pending motions that need to be resolved. Is that accurate, Mr. Sala?
At this point, Your Honor, I think we do have a plea agreement that if the court accepts and agrees with, we could resolve this case in lieu of trial.
Judge, I received an email from Mr. McCready about this. He still needs to talk to the victim, but I think the parties are very close to a resolution. So if we can set another pretrial, Mr. McCready's ill today. Otherwise, he would have taken care of it before today, I believe.
I have no objection. My client's not incarcerated, Your Honor.
Okay. Let's set it then for March 5th at 8:15 a.m.
Your Honor, I have a hearing March 5th, the morning.
About March 12th.
That should work.
So March 12th at 8:15 a.m.
That's good with us.
Okay, Ms. Arnold, can I ask the prosecutor's office to do a stipulation in order for that adjournment?
Certainly.
Okay. Anything else we need to address today?
No, Your Honor.
No, thank you, Your Honor.
All right. Thank you then, Mr. Bishop. You can go ahead and log out.
Thank you.
Thank you, Your Honor.
Mr. Murphy, are you ready to proceed with Mr. Blevins?
Yes, Your Honor.
This is file 23-21355-FC and 24-21929-FH. People versus Nicholas Montgomery Blevins. We are here today for a hearing on failure to appear at sentencing in the 24 case and a failure to appear at a violation of probation sentencing in the 23 case. First, can I have the attorneys place their appearance on the record, beginning with Ms. Orman.
Allison Arnold for the people.
Matthew Murphy, appearing on behalf of Mr. Blevins.
All right, and Mr. Murphy, where do we stand with Mr. Blevins' cases today?
Your Honor, in regards to the contempt of court, Mr. Blevins wants to plead guilty, accept responsibility for that today. Then ask the court to set sentencing. I don't know if we need to do an updated PSI or not. But I do think I talked to my client, he hadn't received a copy of it before today, so I was going to mail him one. He would be willing to proceed today with sentencing if the court was willing to, but again, if the court's not, we just ask the court, again, accept the plea and the contempt and then set sentencing at a later time.
Okay. Mr. Blevins, would you raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Nicholas Montgomery Blevins?
Yes, sir.
Mr. Blevins, with respect to the 23-21355-FC file, that is a well, I guess they're both contempt, so I apologize. So do you understand the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, sir.
Do you understand that you have a right to contest the contempt of court charges and have a trial on it?
Yes, sir.
Do you understand that throughout the trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You are not required to testify at the trial. No one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you also have the right to testify at your trial if you wanted to testify.
Yes, sir.
How do you plead to the charge that you failed to appear at your sentencing in the 24 case?
Guilty, sir.
How do you plead to the charge that you failed to appear for your violation of probation sentencing in the 23 case?
Guilty, sir.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
So you had previously accepted a plea deal in the 24th case and entered a plea to 2 counts of assaulting, resisting, and obstructing a police officer. Is that correct?
Yes, sir.
And that was set for sentencing on January 9th, 2025. Is that correct?
Yes, sir.
And in the 23 case, you had pled guilty to a probation violation that stemmed from those 2 R&O counts. Is that right?
Yes, sir.
Sentencing for that was also set for January 9th, 2025. Is that right?
Yes, sir.
And you did not appear here in court for that sentencing. Is that right?
No, sir. Yes, sir.
All right, I will accept the plea. It's been pleas they have been given understandably, voluntarily, and accurately. Mr. Blevins has had full knowledge of his rights. He's had competent counsel. Before the court passes sentence, Mr. Murphy, is there anything you want to say on behalf of Mr. Blevins? And at this point, I'm just going to sentence on the contempt. I'm going to reschedule the sentencing hearing for the underlying charge of probation violation.
Your Honor, in regards to the contempt of court, I was going to ask the court to sentence Mr. Blevins to credit for time served. I don't want to ask for a fine because I think he's going to have enough to deal with if he's continued on in the recovery court. He has been in jail since Friday. If he has a cash bond, I believe he does. That means he has a few days credit. I believe he has a pending R&O charge downstairs. Just want to make sure the court's aware of that. In speaking with him and the police report and going over the police report, my understanding or from my anticipation is we'll probably set that for an exam. So I'll probably be asking for a PR bond on that down in district court when we come up on that. But I would ask the court to consider credit for time served and contempt. I believe that would be appropriate. And then again, I guess set sentencing for as soon as the court could find in a schedule to do so.
Mr. Blevins, is there anything you want to say on your own behalf before the court passes sentence?
No, sir, just that I don't understand why I keep having running with this same officer with the same exact charges, and it's just I don't know, sir. It's just
That's fine, Mr. Blevins. That doesn't have to do with the contempt. We'll deal with that.
Okay. I'm sorry. No, sir. I'm sorry. No, I'm sorry.
All right. So in the 23 case, Mr. Blevins failed to appear at arraignment. He failed to appear at the original sentencing, and then he's failed to appear at the sentencing on the violation of probation. And then obviously failed to appear on the same date for the 24 case. It's unfortunately a common occurrence that Mr. Blevins does not appear for court hearings, and at this point, I don't think credit for time served would be appropriate. He's going to be sentenced to the court that Mr. Blevins served 93 days in the Monterey County Jail with credit for what day, Mr. Blevins, did you get arrested?
Friday. I'm not sure the date, sir.
Okay, so credit for 5 days served. And I will set sentencing for February 20th at 8:15 on the other charges.
Thank you, Your Honor.
Thank you. Mr. Blevins, you can let the officer that's with you know that you're done with court for today.
Thank you, Mr. Blevins. I'll talk to you again soon, okay?
Oh.
Thank you.
Mr. Dagger Margosian, are you ready to proceed with Ms. Edwards?
Yes, Your Honor.
And Mr. Malero, Ms. DeHart is here in the courtroom. Are you going to need to speak to her before going on the record?
Not unless she wants to speak to me, Your Honor.
She's saying yes. So Ms. DeHart, if you'll step outside to the iPad, you'll need to turn the camera on and unmute the device. Okay, this is file 25-22100-FH, People versus Cateresa Edwards. We are here today for a pretrial conference in this case, as well as a hearing on an order to show cause with respect to alleged bond condition violations. And we are proceeding partially in person, partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Your Honor, Michael Dagger-Margosian for Miss Edwards. Judge, if I'm not mistaken, I think we have pretrials on this case and also on another case Miss Edwards has set for March 19th. I thought that today was just the bond violation.
Oh, I apologize. It looks like you're correct, Mr. Dagger-Margosian. Okay, so just the show cause hearing. Miss, you are Cateresa Pearl Edwards.
Yes, I am.
Ms. Edwards, have you received a copy of the motion, affidavit, and order to show cause?
Yes.
And that document alleged that you violated the conditions of your probation by testing positive for methamphetamine and amphetamines from a screen collected on January 28, 2025. Do you understand that?
Yes.
Do you understand the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, I do.
Judge, I don't mean to interrupt. I've sent an amended violation where she had another positive that should be in the file. In addition to that, I just received another positive test for meth and also amphetamines for a test that was taken on 2/8.
I don't have the amended in the file. Okay, Mr. Dagger-Margosian, have you seen that document?
Your Honor, I haven't seen the amended violation. I have seen the original violation that was issued, and we were made aware of it orally just by Mr. Coast right there. So I'm okay with proceeding.
All right. All right, so I've had the bailiff hand a copy of the amended motion affidavit order to show cause to Ms. Edwards. Mr. Dagger-Margosian, do you know how Ms. Edwards wants to proceed today?
Your Honor, I spoke with Mr. Coast recently about this violation. If the court is willing to maybe push this onto the pretrial date of March 19th, I expect that the underlying cases will be resolved by way of plea at that date. I just need to, Mr. Hartung and I are still working those cases out. But I do expect that we'll resolved by way of plea. And I think other than these violations, Ms. Edwards has been compliant and successful on bond. So that's my position, and the court, I think the court is somewhat familiar with this case. We have had some discussions on this already, so that would be my request. Assuming Mr. Coase would be okay with that as well.
Judge, the only problem I have is, I mean, this is 3 consecutive positives now. She tested positive 128, 25, and also 28. We have meth involved. We have cocaine, THC. I mean, she is testing, but I wouldn't say she's been compliant, however.
Judge, if we can chime in, she has delivery charges and animal cruelty charges in circuit court. So I think that if she's using, she's a danger to other people and animals, given those allegations. She was bound over on those charges. So I think that some sort of bond should be set. And if she's unable to post that bond, release should only be to an inpatient facility.
First of all, there was a bond. Second of all, I'm not sure if Ms. Arnold is fully aware of the circumstances of this case. I would expect that that may change the people's position. She was released on bond for a particular reason after speaking with this court and after speaking with Mr. Hartung. So again, I think it would be appropriate if I don't really want to set this for a hearing. Like I said, I think this is going to all resolve. I would ask the court for her to continue testing, and I think just to address what Mr. Coase said, aside from these 3 tests, I do realize there are 3 violations, but before those, she was testing and those were negative, is my understanding, and I believe that moving forward they will be negative as well. Regarding the animal cruelty cases, those animals have already been surrendered. She doesn't even have possession of them anymore.
Well, obviously, the current apparent non-compliance with the bond conditions is a concern in terms of whether the bond is appropriate. Testing doesn't do a lot of good if we just ignore consecutive. She's obviously, if we ignore evidence that someone is using and consistently using multiple substances, that simply can't be tolerated.
Can I say something?
I don't know if Mr. Dagmar does not want you to say anything at this point.
Ms. Edwards, let's hear from the judge, please.
So here's what I'm going to do. I'm not going to modify the bond right now, but I'm going to direct Mr. Coase to issue a warrant upon the next positive test. So if the last positive test was February 5th.
Judge, actually, the last positive was on 2/8.
On 2/8, well, it still should be cleared, right?
Correct. Today it should be cleared. She was testing today.
All right. So if there's another positive test, I'm going to direct Mr. Coase to issue a warrant, and Ms. Edwards would be taken into custody at that time, and obviously the bond conditions would change at that time, and then we'd be looking at a situation where I would only be releasing to an inpatient facility, because this has to come under control and it has to happen now. And so this is the last opportunity to make that happen.
And Judge, are we considering a missed test a positive test?
Yes.
Very good.
All right, so it looks like this is set for March 19th at 8:15. So we'll set the attempts over to that date as well. All right. You're all set for today then, Ms. Edwards.
Thank you.
Okay, Mr. Malero, are you ready to proceed with Ms. DeHart?
Yes, I am, Your Honor.
Ms. DeHart, you want to come forward to the podium, please? All right, this is file 25-22096-FH and 25-22097-FH. People versus Victoria Marie DeHart. We are here today for a pretrial conference in both of those cases and proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Was not able to hear you, Mr. Malero.
Yeah. How about
Okay.
now, Judge? Can you hear me now? How about now? Now?
Now we're good.
Okay. Salvatore Malero on behalf of Victoria DeHart.
And Miss, you are Victoria Marie DeHart, correct? Okay. Mr. Malero, where do we stand with Ms. DeHart's case today?
Your Honor, we're asking to adjourn this matter for an additional pretrial. It's the first time up. And Ms. DeHart is compiling some information for me to review, and then we would, I think, could seek a possible resolution in this matter. That is my request.
Ms. Arnold, anything to address from the people's side?
No, we agree with that request.
Judge, she's currently on bond conditions. Her last 3 tests have been negative. She's doing very well.
Okay. All right, how about March 19th at 8:15 a.m.?
That's fine, Judge.
And Mr. Malero, would you prepare a stipulation in order for that adjournment?
Yes.
Okay. So Ms. Dart, your next date is March 19th at 8:15 a.m. You can attend in person like you did today, or if you prefer Zoom, you can attend by Zoom. Right, thank you.
Thank you, Your Honor.
And Mr. Malero, I also have Mr. Satterla is here in the courtroom. You need to speak to him.
I do.
Okay, Mr. Satterla, if you step outside to the iPad, you'll be able to speak to Mr. Malero.
Thank you, Judge.
Okay, are we ready to proceed, Mr. Hoover?
Yes, Your Honor.
Okay.
Your Honor, I'm wondering in the meantime, if it would be possible to do a breakout room with Mr. Merritt.
Sorry, I didn't realize that he was there. Okay, this is file 24-22039-FH People versus Ryan Patrick Hoover. We are here today for a pretrial conference in this case and proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Good morning, Your Honor. Fabiola Galguera, P84212 on behalf of Mr. Hoover, who's present and standing to my right.
Thank you. And where do we stand with Mr. Hoover's case today?
Your Honor, when we last came before the court, we said that Ms. Arnold and I would meet to discuss potential plea offers. We did in fact meet. We are making leeway towards potential resolution in this matter. So I would ask that we set this matter out in another 45 days so that Ms. Arnold and I may continue to discuss potential resolution in this matter.
Ms. Arnold, anything to address from the people's side?
No, we concur with that request.
And Your Honor, if I may briefly, last time we were here, also, there was the matter of a motion that we had filed, to which Ms. Arnold filed basically a response saying that there was really no objection given what was in the file, but she was being covered by another prosecutor. So we never really addressed whether that motion was pending or not.
Okay, I was just going to ask about that. And Ms. Arnold, I don't know if you're prepared to address that issue now. There
Judge,
was, go ahead.
Go ahead, sorry.
There was a motion regarding some rape shield evidence filed by the defense, and I've been kind of kicking along with these pre-trials. I don't know if.
Right, we did file a no objection motion. We don't object to the use of that evidence on the basis of the rape shield law. There might be other reasons we may object at trial, depending on how the evidence comes in, but we agree it is admissible, would not violate any rape shield protections.
So at least
I'm not sure if we need an order on it, but I would just ask the court to grant the motion and allow us to argue if there's any other basis to object to its admissibility.
Okay, and Ms. Galguera, is that acceptable if the court enters an order to that effect?
Yes, Your Honor.
Okay. I will do that then, and we'll send you each a copy. And let's see, you had asked for 45 days, is that?
30 to 45, whatever the court finds suitable.
Okay, how about March 19th at 8:15?
Yes, Your Honor, that works for us. Thank you.
Judge, I may not be here on the 19th. Does the court have a docket on the 26th? And would that be a problem to go to that date?
I am out that week, so the next week would be April 2nd.
If we could go to the 2nd, I'd appreciate it. And if we reach a plea offer before then, and we're ready to go, we may contact the court and request that that be moved up if that's agreeable.
That works.
Absolutely.
So April 2nd, then at 8:15. Okay, anything else we need to address today?
Not from the
No,
defense, Your
thank you, Your Honor.
Okay, thank you for your time, and you're all set.
Thank you.
Judge, do you have a Minder on your docket for today?
I do. Let me see if they have a second jail pod available for us.
Okay.
Okay, Mr. Dagger Margosian, Mr. Hartung had been here in the courtroom and he stepped out. I don't know, Ms. Arnold, are you able to handle this one,
That would be
or
great for Judge
should we wait for Mr.
I am
Hartung?
not. He has 3 pre-trials this morning and I haven't discussed them with them.
Okay,
So
so,
district court, Your Honor, so you can be right back.
okay, so as soon as Mr. Hartung gets back, we will proceed with Mr. Merritt's case.
Thank you.
Mr. Glazer, do you need to speak to Mr. Minder?
Yes, I do.
Okay.